This is in the District Court of Greenwood County, Kansas. Case is entitled The Matter of the Paternity of N.J.W. by and through Tanner Whitaker, petitioner, versus Danica Baker, respondent.
Susie Lockup, hearing on behalf of Tanner Whitaker, the petitioner.
Your Honor, Darren Patterson, attorney on behalf of Danica Baker, the respondent who appears personally with me.
We're set today for an objection on a Rule 170 notice. Some final orders. Are you all still having disputes over the journal entry?
Judge, if I could, I've had time to talk to my client, and I think I can narrow this down to a couple of real quick things just for the court to look at.
And Darren, I don't know if I'm having a little bit trouble hearing you. I don't know. Can you hear him okay, Susie?
It seems a little further away than normal.
How about now?
Maybe about the same. I've also there's some workers outside running machines, so that may have something to do with it too.
Let me try this. How about now?
There, that's better.
Okay. I got a new Zoom with all these other things that changed some stuff on my equipment, so I'm trying to get adjusted back to it. Sorry about that, Judge.
Oh, you're fine.
Judge, as I was saying, I think I can make this fairly quick on the journal entry issue and just narrow in on just very two quick basic little things. And if the court had a copy of its ruling in hand, which at page 7 is the actual rulings that the court made, and then a copy of the proposed order in hand, I will direct the court to very specific places where I think the proposed order does not match what this court has ordered.
All right. You're talking about the proposed order submitted under Rule 70 from Ms. Locke?
Yes, Judge.
Okay, I have those in front of me.
Judge, I would first start with on your orders, which is on page 7. It would be the further finding and orders of the court section, looking at number 1. On that order, if the court then goes to the proposed order at page 3, which is then on that page, paragraph K, as in king. The court ordered that text messages shall be responded to within 24 hours. The way that K is worded does not match that. The 12 hours is fine, but 24 hours should be the limit. But then it goes on to add a time frame of 7 days. So it seems to be vague as to whether somebody has to actually respond in 24 hours or 7 days. The court ordered 24 hours. So my fear is that somebody's going to think they have 7 days to answer based upon the way that's worded versus what the court ordered. So I think that should be modified.
All right, Ms. Locke, your response?
Judge, I hadn't heard that objection before. I don't have any issue with removing the 7 days portion and just leaving it at 12 to 24 hours.
No objection to that modification, Judge.
Okay. Go ahead.
Nope, that's fine. I'll just make the change.
All right, and I'm looking at the language here. Maybe give me a second. Does co-parents commit that if a or multiple decisions, is that the way that's supposed to read?
If a decision or multiple decisions, I think is how it is supposed to be.
And
that's just straight from the DC recommendation.
And I guess where I was confused a little bit, and maybe Ms. Locke can point this out, I didn't see a specific place in the proposed order that said how communication, what methods of communication will be used.
It's A, 5A. The parties will communicate via text message.
Okay.
Even small wording sparks big worries about co-parenting fairness.
So that clears up then that K, Judge, and with that, then no further objection to that one.
Okay.
On your order down further, paragraph 4. And that is apparently addressed in the proposed order on page 5. It appears to me maybe 13B. The court last part of the sentence, or in the same building where the child could overhear, is missing from paragraph 13B, which I think is an important one to make sure that there's no mishaps. So if the child's in the same building, there shouldn't be any discussions that would shouldn't be around the children, the child shouldn't hear.
So basically, you're saying it should read or in the same building at the end of B.
As the court ordered, yes, that's all I'm suggesting. It should have that in there too.
All right, Ms. Locke,
Should that be an or? Or do you want within hearing range in the same building?
well, the way it's worded in my order is neither party is to talk derogatorily about the other parent when the child is within hearing range, comma, or in the same building where the child could overhear.
So while the child is present or within hearing range or in the same building where the child could overhear. Would be in B.
Correct.
I can make that change.
Judge, that's it on the proposed order, except as to child support.
Okay.
And I would move on to the child support issue.
All right, Ms. Locke, anything else regarding the journal entry portion?
No, Your Honor.
Okay,
Judge, on the child support, the court did order, or it made specific findings as to what the party's income should be for child support, then did order that child support worksheets be completed. I have submitted a proposed child support worksheet, and which is different from the proposed worksheet of the petitioner. I would point out some very specific differences that I think are very relevant, and probably the one of the petitioner does not comply with the child support guidelines.
okay,
And I have both proposed child support worksheets in front of me. I don't know if the court does also.
well, give me just a second, because I'm looking at the document you filed that's proposed child support. And then it has a worksheet attached to it. Is that the one you're referring to?
That would be one of them I'd refer to as the respondent's proposal.
Okay, and Ms. Locke, did you submit a worksheet as part of this?
Your Honor, I don't believe it was submitted to eFlex. It was submitted to Mr. Patterson as part of the Rule 170 and in prior discussions before we filed the Rule 170.
Okay, I don't think I have a copy of that then, do I?
You might not if it did not go through eFlex.
I thought it was attached to the proposed order because you did address child support in that proposed order.
I did, but I think that was when I sent it to you and it did not end up getting filed with the Rule 170 notice.
It's not attached to my Rule 170 notice.
Okay, well, I will just point out what I think the errors are and why the one I'm presenting is appropriate then, Judge. Unless Ms. Locke wants to email one in real quick to the court, but otherwise I'll just point out what I think it should be.
All right, go ahead, Darren, and
Judge, I would just tell the court that the income amounts that both parties have on their proposed worksheets are identical based upon the court's order. As you get on the proposed worksheet that I presented, and when you get to paragraph C, it does have a paragraph C2 where you're required to put court-ordered monthly child support paid. And that's where the petitioners is lacking. They have not put that in there. Instead, the petitioner would suggest that we use a multifamily application for that child where there's a child support order already made. I would tell the court
Each side tries to prove their version fits the law more closely.
that in the child support guidelines at section 4F is the multifamily application. At the end of that paragraph, I'm going to quote it. The multifamily adjustment must not be used for children who are already part of another child support order. There is a child support order on file for the second child that is being suggested. And that's in the other Greenwood County case that you're not a part of, but it does have that child support ordered at the amount that I have set in the proposed order. So there should not be a multifamily adjustment, and there should only be the amount of the other order put in there, $44.
Right, Ms. Locke?
Your Honor, I think these are things that Darren and I could have spoken about, but he is electing not to do that. So yeah, we can make that change. That's an easy modification. I think the true issue with child support is which parent is going to be responsible for direct expenses. And then Mr. Patterson and I can work out the worksheet, but Mr. Patterson is suggesting that his client should be responsible for direct expenses. I am suggesting that my client be responsible for direct expenses. The court did not make a determination on that. So I think that is really the crux of the issue, and nominal aspects of the child support worksheet are easily resolved between the parties.
All right, so we need to sort out today who's going to pay the direct expenses.
Correct.
I would agree with that, Judge, yes.
Okay. Ms. Locke, I'll allow you to make argument.
Thank you, Your Honor. So the child support guidelines make this decision discretionary for the court, looking at several factors. The factors include historic roles and familiarity with the needs of the child, performance under previous arrangements, payment of medical bills and dental bills and other direct expenses, and then the party's ability to co-parent. If the court will remember the significant amount of evidence that was taken during this case, there was a clear demonstration that Ms. Baker has challenges financially. There was an argument in the court addressed that my client should be responsible for domestic conciliation because there was an inability to pay. There's been ongoing correspondence from the domestic conciliator about Ms. Baker's ability to pay. There were concerns and statements and exhibits showing this idea that there is paycheck to paycheck concerns in Ms. Baker's household. We're not trying to make light of that, and there would still be a child support obligation owed by my client. But what is also apparent is that my client has more discretionary income. Therefore, any modifications to direct expenses, any significant direct expenses that came up, are more aptly and promptly paid by the client that has a more significant monthly income. Both parents have equal parenting time. They both spend equal amounts of time with the child in their home, and they're both paying kind of those regular food. They're both providing clothing in their homes, those types of things. So we're talking about the more significant purchases, extracurricular activities, school fees, school lunches, if those ever become applicable, that we're looking at a child support obligation for. And our suggestion is that Mr. Whitaker has, again, more discretionary income and the ability to pay those as the higher wage earner. There, again, is that history of payment concerns and the ability to make prompt payments on mother's side, which was argued by her counsel, as well as significant exhibits provided by her counsel as to the ability to pay and her income. There's already a plan for alternative dispute resolution for any issues that come up. So if the parties cannot agree on what extracurricular activities Nora is going to participate in or things of that nature, that's already dealt with in the parenting plan. And then my client would obviously be the one with direct expenses to be responsible for paying those. So our proposal, Judge, is that Mr. Whitaker be responsible for paying the direct expenses. And then, as is typical, there would be just a shared income tax deduction. So there would be no income tax considerations on
Money, trust, and communication failures push the courtroom to edge.
the worksheet, that they would alternate Nora for child support purposes or in tax purposes. If there is going to be some ruling on the child tax credit, we would just ask that we be able to offset that income tax consideration on the child support worksheet. And like I stated, and what would be shown is that Mr. Whitaker would still owe support to Miss Baker. We calculate that at about $520 a month. Obviously, that would be potentially be modified based on rulings here today, and conversation between myself and Mr. Patterson. So he would be having a monthly child support obligation while also being responsible for Nora's direct expenses.
All right, and is all of this reflected in the proposed worksheet you emailed to Darren?
It is, Your Honor, and it's reflected in the proposal that's in the Rule 170 order.
Okay, do you have the ability to email that to Angela?
The proposed worksheet?
Yes.
Yep, I can do that right now.
Okay, while you're doing that, I need to look up something real quick, Darren, before I allow you to make argument.
Yes, Judge.
And Your Honor, I know you're looking something up. When I run the worksheet with the modification that Mr. Patterson was making argument about at the beginning of his argument, the obligation would be $702 a month.
And your worksheet wouldn't change, Mr. Patterson. Your worksheet, you have your client paying the direct expenses, is that correct?
That is correct, Your Honor.
Okay. All right. Just 1 second, and then Darren, I'll allow you to make argument. All right, go ahead, Mr. Patterson.
Thank you, Judge. Judge, there are those factors that was just stated to the court that the court should take into consideration. Of those factors, I would just point out the last one, the ability of the parties to communicate. Well, I think that's pretty clear from the DC report, as well as what the court heard. These parties have no ability to communicate with one another. So that when it comes to direct expenses of the children, it becomes very important, because what happens, and I think in the idea behind the child support and guidelines and the way they went is to set up the direct expense method, was so that one person doesn't end up paying for stuff and then they can't get reimbursed for it. They can't get their portion of it. Well, that's what's going on with my client. I would tell the court that my client's here. She's ready to testify if she needs to be sworn in, but she would tell the court that she's been responsible for paying direct expenses for various items, and she does not get reimbursed. There was a purchase of eyeglasses. She's requested reimbursement from the petitioner. She has not got reimbursed. She's paid for the school expenses. She's paid for the equipment for extracurricular and has not got reimbursed for those things. So she is going to take care of her child and she's going to pay those things. That's what direct expense is for. But when you have such a communication problem that they can't discuss who's going to pay for something, or do we need this thing, and she buys it anyway, well, she's out of luck trying to get reimbursed if the court orders him to pay the direct expenses, because he's not going to pay her for what she ends up buying because he refuses to. This is a 6-year-old young lady. Who's going to know for a child 6, 7, even getting up to 10, 12 as a young lady, who's going to know better than mom what that child needs? So by placing the direct expenses with the mother, you do set it up better for the child to receive the things that she may need. And there won't be a need then for my client to ask for reimbursement for things that she has bought, which has done. And she's ready to testify about those things. So this is to simplify the life for her so that she can make sure her child has everything. And then at that point, she can just receive the child support, and that's it. And she doesn't have to communicate with him about those things. So we are asking that she be ordered to pay the direct expenses. For that reason, we think equitably it makes sense.
The judge steps in, ruling on money disputes and tax credits.
All right, thank you, Mr. Patterson. Well, the court obviously heard lots of testimony regarding the parties' ability to communicate and all of their interactions with each other. I think in this case, mom is the one who should be paying the direct expenses. I think she has the most day-to-day experience with the dealing with the school and the medical appointments and the day-to-day things going on with the minor child, that it's the court's going to order that she be allowed to pay the direct expenses.
And basically, Judge, that was it. I didn't have any further arguments about the child support worksheets or proposals.
Your Honor, my understanding is that Mr. Patterson was also asking that she be awarded the tax credit or the tax deduction for Nora, but if that is being withdrawn.
Well, alternating year to year, which I think is what you just said, isn't it, Ms. Locke?
Yes, but my understanding from your motion was that you were asking that she be allowed to claim Nora for 2 years and then it would be alternating. But maybe I misread the motion.
Well, since Ms. Locke brought it up, I would make that argument then, Judge. It is in the motion, have been noticed up. I would tell a court that for 2 years running that taxes have been filed. The petitioner has taken the tax exemptions for the child, and my client has tried to get him to let her have them at least one of those years. He's refused. So it would only be fair that she get 2 years in a row and then they alternate back and forth. That would even it back out. And that is the request in the motion.
Response?
Your Honor, yes, Your Honor. Consistent with the temporary order in this case, which includes child support, Mr. Whitaker was awarded the tax provision, and there is an offset on the child support worksheet that he has been paying on for the income tax consideration. So the idea that he was operating improperly or inconsistent with the order is incorrect. She was receiving additional child support while he received the tax credit. We would ask that the parties alternate the credit going forward. If the court is going to order something otherwise, then there would be an obligation that the child support worksheet be modified to give an income tax consideration to one party or the other, depending on who is being awarded those additional years of tax credits.
I'm denying the request, Mr. Patterson, and just ordering that it alternate.
Yes, Judge.
So does that clarify then all of the pending child support related matters?
I believe it does, Judge.
All right, and Ms. Locke?
I think it does too, Your Honor. And when I am running a worksheet, it is the same as Mr. Patterson's. We would have no objection to his worksheet being adopted.
Okay. Well, if you all will prepare the modifications that have been addressed here today and get those submitted to me, that would resolve all pending matters regarding this case.
It
Judge,
would, Judge, and I would just ask for one additional item in this order at the very end. If the court could show that I have withdrawn on behalf of the respondent, and I have discussed that with my client already. She's aware of that. So at the time that the journal entry is filed, if that could be included in the journal entry, it would save a motion and order later.
All right, Ms. Locke.
That is the same for me, Your Honor. I have a pending motion to withdraw. I was dealing with this final issue, and then my pending motion could be ruled upon and I could withdraw as well.
Very well. So ordered.
Thank you, Judge.
All right. Thank you all. If there's nothing further.
The case wraps up, attorneys withdraw, and the court closes. It's a clean ending after sharp disputes over family obligations. All right, guys, if you enjoyed this breakdown, hit like, subscribe, and we'll see you in the next video.